The Supreme Court just issued a 6-3 emergency ruling that is currently tearing through the foundations of the American legal system. If you live in the United States, your world just changed. This isn't a minor procedural update. It is a seismic shift in how federal power works in this country. We're talking about a decision that fundamentally rewrites the rules of who has the authority to protect your rights, how corporations will be regulated, and whether your constitutional protections stop at the state line. Washington is in a state of absolute whiplash. Within minutes of the decision dropping, legal teams at the Department of Justice and state attorney general offices across the country were pulled into emergency sessions. Before we break down the explosive details of what this means for your healthcare, your taxes, your voting rights, and your basic freedoms, hit subscribe so you never miss a major legal alert like this. We are witnessing the most aggressive Supreme Court term in modern history, and you cannot afford to be behind the curve. Let's get into what actually happened. In a 6-3 decision that fell strictly along ideological lines, the Supreme Court effectively dismantled a legal framework that has governed America for decades. They struck down two massive pillars of federal power in one ruling. First, they eliminated what's known as the nationwide injunction, the ultimate legal stop button that allowed a single federal judge to freeze a law across all 50 states. Second, and this is what legal experts are calling even more consequential, they overturned Chevron deference, a 40-year-old doctrine that gave federal agencies the power to interpret ambiguous laws. Think about the scale of this. For the last 2 decades, more than 60 nationwide injunctions were issued by individual judges, effectively allowing one person in a black robe to override the will of Congress or the president for the entire country. The Supreme Court just called this judicial overreach and ordered it to stop. But simultaneously, there are currently 3,247 active federal regulations governing everything from the water you drink to the medications you take that were issued under Chevron deference. Every single one of those regulations is now potentially vulnerable to legal challenge. The Supreme Court just declared that lower court judges no longer have the authority to issue universal injunctions that apply to everyone in the country when only a handful of specific plaintiffs are involved in the lawsuit. And they declared that federal judges, not agency experts, will now decide what ambiguous laws mean. The majority opinion makes it crystal clear that courts have both the authority and the duty to interpret federal statutes independently, even in highly technical areas where agencies have specialized knowledge. But here's the part that has everyone panicking. There are currently 47 active cases in the federal court system right now involving immigration, gun control, and environmental protection, where states are seeking these exact kinds of blanket protections. By tomorrow morning, those legal strategies are dead. Within 6 hours of this decision being published, 23 separate lawsuits were filed targeting regulations that industries have wanted to challenge for years but couldn't. The challenges have already started, and they're coming from every direction. The reasoning behind this 6-3 split goes much deeper than a simple rule change. It's an ideological war over the meaning of Article 3 of the Constitution and the separation of powers. Justice Gorsuch didn't just look at modern law, he went back to the year 1789. He cited a mountain of historical evidence from the founding era, arguing that federal courts in early America never once issued an injunction that applied to people who weren't actually in the courtroom. He pointed to 12 separate founding-era cases where judges explicitly rejected requests to apply a ruling to the whole country, even when the lawyers argued it would be more efficient. On the Chevron issue, Gorsuch traces the history of administrative agencies back to the founding and makes a startling claim. The entire modern administrative state operates on constitutional theories that the framers would have found incomprehensible and dangerous. He cites James Madison's Federalist No. 47, where Madison warned that the accumulation of legislative, executive, and judicial powers in the same hands is the very definition of tyranny. When agencies both write regulations, enforce them, and adjudicate violations, they're doing exactly what Madison warned against. And Chevron deference made it worse by requiring courts to rubber stamp agency interpretations. Justice Thomas went even further, arguing that both of these practices violated Article 3 of the Constitution. A judge's job is to settle a fight between person A and person B. According to Thomas, a judge has no business making a policy decision that affects millions of people who didn't even sign the lawsuit, and courts have no business transferring the judicial power to interpret laws from judges to executive branch agencies. The dissenting justices, led by Justice Sotomayor and joined by Justice Kagan, issued warnings that sound like sirens. They argued that this historical analysis is a fantasy that ignores the reality of 21st century governance. Kagan warned that this decision will cause regulatory chaos and hamstring the government's ability to address complex modern problems that the framers never anticipated. She argues that Congress intentionally delegates interpretive authority to agencies because they have the expertise that generalist judges lack. Sotomayor cited civil rights cases from the 1960s where nationwide orders were the only thing that stopped systemic discrimination. But the majority's response was chilling. They suggested those 1960s-era procedures might have been wrongly decided from the start. This is why legal analysts are calling this an originalist earthquake. The court isn't just changing the rules for today, they are trying to reset the entire federal judiciary to the way it functioned 230 years ago. And the immediate political fallout is already beginning to reshape the map. Within 3 hours of this ruling hitting the wires, the earthquake began. Attorneys general from 12 different states filed emergency motions in their ongoing federal cases. Texas immediately cited the decision in 3 separate lawsuits challenging federal border policies. Florida invoked it in cases involving social media regulation and election integrity. Arizona used the ruling to demand that a border security dispute, which had been frozen for 8 months, be unfrozen immediately. The speed of these responses tells you everything. Legal strategists aren't waiting for the dust to settle. They are using this ruling as a battering ram to break through federal roadblocks. But simultaneously, the corporate litigation explosion began. The American Petroleum Institute filed suit in the Fifth Circuit challenging EPA regulations on methane emissions from oil and gas operations. Their argument is simple. Without Chevron deference, courts must interpret the Clean Air Act independently, and under that standard, the EPA exceeded its statutory authority. The estimated cost to the industry if these regulations stand is $82 billion over the next decade. The pharmaceutical industry moved even faster. The Pharmaceutical Research and Manufacturers of America filed 3 separate lawsuits before midnight targeting FDA regulations on drug pricing transparency, accelerated approval pathways, and biosimilar approval standards. Financial services companies are targeting regulations under Dodd-Frank. The Securities Industry and Financial Markets Association filed suit challenging SEC regulations on cryptocurrency, private fund advisors, and proxy voting rules. Agricultural groups are challenging EPA and FDA regulations on pesticides and water pollution. Technology companies are targeting FCC regulations on net neutrality. Legal analysts estimate that industries will file between 800 and 1,200 lawsuits challenging federal regulations within the next 90 days. The cumulative economic impact of these regulations totals approximately $3.7 trillion in compliance costs, economic activity, and market effects. Even if courts overturn just 15% of the targeted regulations, we're looking at the largest deregulatory event in American history, accomplished not through legislation but through litigation. At the Department of Justice, sources are reporting that senior attorneys held an emergency conference call at 7 a.m. They are scrambling to figure out how this affects the government's litigation strategy in 23 ongoing national cases. The White House counsel's office is reportedly advising federal agencies to prepare for state laws they thought were blocked to suddenly start being enforced again, potentially as soon as next week. Inside federal agencies, this ruling has triggered a level of panic that hasn't been seen in years. The EPA convened a task force of over 100 attorneys to review its entire catalog of regulations. Internal estimates suggest that between 200 and 400 EPA regulations could be successfully challenged, covering everything from carbon emission standards to water pollution limits to hazardous waste disposal requirements. The FDA released an internal memo instructing staff to prepare detailed scientific and legal justifications for every major regulation, anticipating waves of litigation. The SEC held an emergency meeting of its 5 commissioners to discuss litigation strategy. But here's the question that should keep you up at night. If your basic rights depend on which state you happen to be standing in when you use them, do you really have constitutional rights at all? Or do you just have geographic privileges? And if protecting public health requires expert judgment on complex scientific questions, but judges without that expertise now make the final call on what regulations are legally permissible, who's really making decisions about your health and safety? Let me explain what this means on the ground, in ways that will directly affect your life. This ruling doesn't just change abstract legal theory, it completely transforms how legal battles are fought in America and what protections you actually have. For the last 2 decades, advocacy groups on both sides relied on a tactic known as forum shopping. If you didn't like a federal policy, you went to a specific district with a sympathetic judge who you knew would grant a nationwide hold. Between 2017 and 2021, nearly 80% of nationwide injunctions were issued by judges in just 5 specific districts. The Northern District of California and the Northern District of Texas became the ultimate battlegrounds. One judge in Amarillo or San Francisco could effectively veto the president for the entire country. But as of today, that strategy is dead. Now if a group wants to block a policy, they can't just win once. They have to win everywhere. A case that previously required one filing in one friendly district might now require 15 or 20 simultaneous filings across different circuits. Major law firms are already sending emergency memos to their clients. Civil rights litigation, environmental challenges, and constitutional cases could now cost 5 to 10 times more than they did just last month. And for businesses, we're entering an era of patchwork compliance. Imagine you are a multi-state corporation, a bank, a pharmaceutical company, or a tech giant. Yesterday, if a federal regulation was blocked, it was blocked everywhere. You had a single set of rules to follow. Today, that same regulation might be blocked in New York, but enforced in Texas. It might be legal in the Ninth Circuit, but a crime in the Fifth Circuit. The Chamber of Commerce estimates that compliance costs for multi-state businesses could spike by $47 billion annually just to navigate this geographic minefield. The pharmaceutical industry is especially rattled. The FDA depends on national uniformity for drug approvals and monitoring. If an injunction against an FDA rule is narrowed to only protect the specific pharmacy that sued, the rest of the country remains exposed to federal enforcement. This creates a legal lottery where your business's survival depends entirely on your zip code. But let's get to the most volatile part of this ruling. What happens with actual policy enforcement on the ground? The case that triggered this entire decision involved Executive Order 14160, President Trump's plan to effectively end birthright citizenship for children of undocumented immigrants. Before this ruling, 3 different district courts had issued nationwide injunctions, calling the order blatantly unconstitutional. They stopped the government from even beginning to implement it. But the Supreme Court just lifted those stays. Because the court ruled that the injunctions were overbroad, the government can now move forward with enforcing the order against anyone who wasn't a direct party to those original lawsuits. Within 30 days, the Department of State can begin withholding citizenship documents from newborns across vast swaths of the country. This creates a nightmare of geographic citizenship. An infant born in a hospital in Seattle, covered by a local injunction, might be recognized as a U.S. citizen, while an infant born at the same moment in a hospital in Nashville would be classified as a deportable non-citizen. And it's not just immigration. Gun regulations in 6 states are currently frozen by nationwide orders. If those are narrowed, state officials could immediately resume enforcement on everyone except the specific plaintiffs who sued. Access to medication like mifepristone, the abortion pill, is currently held in place by a complex web of injunctions. Under this new ruling, that access could vanish in one state while remaining protected in the next. The court is essentially saying, we don't care if the law is unconstitutional. We only care that the remedy is small. They are trading national stability for a narrow interpretation of judicial power. The FDA is currently defending 34 different regulations in federal court that govern everything from prescription drug safety monitoring to medical device approvals to food additive restrictions. Under Chevron deference, courts upheld these regulations by deferring to the FDA's scientific expertise. Without that deference, industries can now argue that courts should interpret the underlying statutes themselves, and many of these regulations could be struck down or significantly weakened. Consider what's at stake with prescription drug regulations. The FDA requires certain safety testing based on its interpretation of what Congress meant when it passed laws saying drugs must be safe and effective. But those terms are inherently ambiguous. What level of side effects makes a drug unsafe? How much evidence is required to prove effectiveness? For 40 years, courts deferred to the FDA's expert judgment. Now, federal judges with no medical training will make those determinations, and pharmaceutical companies will argue for the most lenient interpretations possible. As if the economic and health fallout weren't enough, we are heading straight into a presidential election year with a legal system that is now fundamentally fractured. Currently, there are 9 nationwide injunctions active across the country, affecting everything from voter ID requirements and mail-in ballot procedures to early voting and voter roll maintenance in 19 different states. Under the Supreme Court's new framework, these protections are no longer a blanket. Instead, they might only protect voters in the specific counties where the plaintiffs live. This creates an absolute nightmare for election administrators. They need to know months in advance what the rules are so they can train poll workers and print ballots. The National Association of Secretaries of State has already issued a warning. If injunctions are geographically limited right before an election, we could see the same state law being enforced in 80% of a state while being blocked in the other 20%. We aren't just looking at a state-by-state election, we are looking at a county-by-county legal patchwork. The question is no longer just who you vote for, but whether the rules of the game change the moment you cross a county line. Civil rights organizations are expressing deep concern that limiting these injunctions forces victims of discrimination to fight the same battle in dozens of different courtrooms before they can achieve any real protection. The NACP Legal Defense Fund pointed out a chilling historical parallel. During the Civil Rights era, nationwide injunctions were the primary tool used to implement cases like Brown versus Board of Education. They allowed courts to prohibit segregation across entire states rather than just in one specific school district. If those cases had been litigated under the framework the Supreme Court just established, desegregation might have taken decades longer. But here's where the constitutional theory crashes into political reality in the ugliest possible way. The Supreme Court's reasoning assumes that if federal statutes are ambiguous, Congress can fix them by passing clearer laws. But that assumption ignores the fact that Congress is fundamentally broken and incapable of passing detailed technical legislation on most subjects. The Clean Air Act was last comprehensively amended in 1990, 36 years ago. The Occupational Safety and Health Act hasn't been substantially amended since 1970. These statutes were written for a different era, with different technologies and different challenges. Without Chevron deference, Congress would need to pass incredibly detailed statutes that explicitly authorize every regulation. Want EPA to regulate a new air pollutant? Congress needs to pass a law specifically addressing it. Want FDA to create new safety testing requirements? Congress needs to legislate the details. The problem is that Congress can barely pass basic appropriations bills, let alone complex technical legislation on dozens of regulatory subjects. What this creates is a constitutional doom loop. Agencies can't regulate without clear congressional authorization. Congress can't or won't provide that authorization. Therefore, problems go unaddressed, risks accumulate, and the government becomes incapable of responding to new challenges. What's really happening here is the most significant shift in governmental power in modern American history, and it's all flowing to one place, the federal judiciary. By overturning Chevron deference and limiting nationwide injunctions, the Supreme Court hasn't just limited agency power, it's transferred enormous authority to federal judges who will now interpret ambiguous statutes across virtually every domain of federal regulation. Federal judges will be deciding questions like, what level of air pollution is acceptable? Which medical treatments are necessary under Medicare? How much exposure to workplace chemicals is safe? These are extraordinarily complex questions requiring scientific, medical, and technical expertise. Federal judges are generalists with law degrees, not experts in toxicology or environmental science. Yet they'll now be making these determinations, and their decisions will have the force of law. By issuing this ruling through the emergency docket rather than waiting for years of lower court litigation, the court has sent an unmistakable message to every judge in America. We are in charge. The court has issued 47 emergency orders in the last 3 years to modify lower court decisions. Compare that to just 19 such orders in the previous 3-year period. The court is no longer a passive observer. It is micromanaging federal litigation in ways that were unthinkable 20 years ago. Whether you view this as appropriate oversight or judicial overreach depends entirely on your perspective. But one thing is undeniable. The era of the activist lower court judge is over. The power has been centralized. This Supreme Court ruling fundamentally rewrites American citizenship, business regulation, public health protection, and the very nature of our rights. We are moving away from a United States and toward a fragmented states where your constitutional protections are only as wide as the courtroom doors, and your safety depends on which judge interprets which regulation. This is a story that is still developing every single hour, as the 30-day clock ticks down, as industries file hundreds of lawsuits, as agencies scramble to defend their authority, and as election administrators try to figure out what rules apply where. We will be here to track every development. If you want to stay ahead of the legal chaos and understand how these rulings actually impact your life, make sure you're subscribed, hit the like button, and drop a comment below. Do you think this decision protects constitutional government or cripples it? Let's talk about it in the comments.